Latest immigration news, what's going on? I was trying to make a live session. I went there live, but nobody was, like 2 people, 3 people. I figured out maybe I should just make a short video, or just make a video and explain what's going on and provide practical tips for immigration court and USCIS. Okay, what's going on is we are seeing a lot of arrests during court hearings and during USCIS interviews, and some people are just afraid even to go to pick up their result. But do not be afraid to go and pick up your result, because they're not sending, especially in Arlington, they're not sending those results. You just have to go there to pick it up so you will know whether you've been granted asylum or not. Okay. And if you're too afraid, maybe you should go with your lawyer and something like on those lines. Maybe they can make an argument for you. Okay. But let's focus with on expedited removal. Expedited removal simply means that if a person happened to enter the United States without inspection and they haven't been here for more than 2 years, they're subject to expedited removal, which means that the officer will hear the case and decide on their fate without court hearing, without them being heard before an immigration judge. So they lose all those benefits of appeal. They lose the right to appeal. There's no right to appeal. They lose when, in case of removal, the person will be barred from entering the United States for 5 years, and the person really has limited venues when it comes to coming back. Okay, that's what's happening. So if you happen to be a person who happened to enter the United States without inspection and you have a court hearing, those are the things you should know. First, you look at your notice to appear. If you were granted parole and you've been here for even between 2 years, like let's say between 0 to 3 years, okay, even those people are the target for expedited removal. Enter without inspection, okay, within 0 to 3 years, expedited removal, subject to expedited removal. When you go to those hearings, ICE is trying to pretty much dismiss the case, detain the individual, place them in removal, expedited removal proceedings, and arrange for transportation, then deport the person. What exactly can you do? Number one, you can try to continue the case for good cause. If you have a good cause, let's say I-130 is pending, okay? You can ask the judge to continue the case. If you have a child who's sick, or you yourself you're not mentally fit to stand trial, you can ask the judge to continue the case. You just have to show proof, okay? For good cause, you can always continue the case. That way, it's going to buy you some time to figure out what are your best options under those circumstances, okay? If that option is not available for you, then you have to have a way to appeal that dismissal order. Or you have to have a way to ask for 10 days so you can reply to OPLA dismissal, motion to dismiss. So you have to have some strategies in terms of what exactly can you do. If you happen to be married to a U.S. citizen, a arriving alien, happen to be married to a U.S. citizen, with parole, file I-130, I-485, all together with USCIS. And it's a good thing if the case gets dismissed, then ICE technically cannot detain you because now you have a green card pending with USCIS. However, the challenge is that, when a person is placed in removal proceedings and that person goes and gets married after being placed in removal proceedings, this presumption of fraud. You really have to have strong and convincing evidence in order to overcome that presumption of fraud, like your marriage is fraudulent. Because once they determine that your marriage is fraudulent, there's no waiver available. There's nothing you can do about it. Yeah, just make sure that you have clear and convincing evidence for the marriage in question. But the good news is that you can file I-130, I-485 if you are having alien and with parole. File it directly with USCIS because USCIS has jurisdiction over that green card petition. Because at that point, ICE hasn't executed any order of removal, and you are in removal proceedings, and the judge does not have jurisdiction over your case because you never left, you just came, right? So that's how it works. That's really something to work on if you have those type of green card marriage and happen to be in expedited removal. You really have to rush and file all those petitions with USCIS. If you happen to, again, enter without inspection, you're having alien but you are not parole, you don't have the parole argument, what are you going to do? Still file I-130 and make an argument for administrative closure of your case. That way, once the I-130 is approved, you can file the waiver of unlawful presence, the I-601A waiver, because if a person is in removal, technically, they cannot, but if they file I-601A, but if the case is administratively closed, they can. But if the case is dismissed, they get detained. So that's why you make the argument for administrative closure and hope that it stands, okay? Those are the things that a person can do. USCIS. If you go to USCIS, during those hearings, they're targeting people who have criminal record, felonies, especially serious crimes. But when it comes to theft-related crimes, even if the crime is not serious, that person is also targeted, okay? Because of mandatory detention that is attached to the Laken Riley Act, remember? Theft-related crimes of violence, okay, requires mandatory detention. Those people too are going to be a target. But let's just say that you have previously been ordered removed, I-130 now is pending, and then they call you for the interview. Do you really have an argument? You just look at your situation. If you happen to be a DACA recipient and you have a valid DACA, you are not subject to removal because DACA is a deferred action, okay? If you have a child that is sick, you are a citizen, try to file for deferred medical action so that you don't get detained because of your previous removal order, okay? If you're TPS holders, I know a lot of TPS has been canceled, but if you're TPS holder, if you among those people who have TPS, then you don't have to worry because TPS is a protection against deportation. You can go to your interview for I-130. If you don't have any of those and they call you for the interview, if you don't go, it's a problem too because now they can come to your house because they know that you're running away. But you can still apply for stay of removal with ICE directly. So there's always something that you can do because you still have to fight. You can't just give in. In terms of I-130 spending, USCIS interview, previously been order removed, what should I do? Those are the things that you can do, the one that we just listed. What else is going on? Arrest, detentions. Those are the things, the news that we're hearing, and a potential travel ban for other 36 countries, and investigation. USCIS is really investigating on those cases. Fraudulent document, fraudulent marriages, previous crimes. They're really investigating. If you go on uscis.gov, you will see that there people have been charged, convicted, have been fined. So a lot is going on. Follow us for more signings. Follow us for more. Until next time. Bye-bye.